So the question is how to format evidence for a letter of protest if the opposing trademark category is different with likely of confusion goods. Very detailed question. The USPTO's response is, hey, we looked at the letter, determined it won't be considered by the examining attorney because it's not meeting some requirements. Protest letter doesn't include evidence to support the identified ground for refusal.
They got the section in there and everything.
Look at that. Right. This could be an attorney asking. Right.
Yeah, probably is, right? No, good question, right? So letters of protest are pretty rare. They don't happen too often. I filed a couple in my career. There's been, of the 1,300 plus trademarks I've filed, probably only a couple have been filed against our applicants. So they are rare, but you do need to base it. What you're trying to do is make sure the USPTO doesn't miss a registration or application, that should concern it. So let's say that you're a senior user, you have a trademark registration and you have a really unique name. You might be in the legal services category, and all of a sudden there's an apparel company called the exact same thing with a really unique name, right? They're not really related, for goods and services perspective, but the names are identical and they're really unique names. You might offer, a letter of protest to the USPTO and just say, hey, just so you're aware, I own this registration over here. It's a really unique name. Here's how I came up with it. Here's what it means. I know this individual over here. They're doing apparel. Although it's not really related, it kind of is, right? And so that way the USPTO can at least acknowledge that your registration, may present a likelihood of confusion with the new application.
So you're
it's just to point out, an issue during the registration process.
In advance, right? It sounds like you're going to do it
prior to the USPTO examiner even doing their own initial examination. You're basically saying, over here. You
probably get a couple extra little brownie points in a way because you're sort of, I guess, volunteering that information. You're not hiding it or trying to get one past them in a way.
Yeah, I mean, for these clients that we're working with right now, who have these bad actors out there, both of the bad actors have filed trademarks preempting our client's application. So we will be submitting letters of protest.
That's great. Okay.
So
thank you.
And in our client's case, the services and the goods are the exact same between the two applicants. So we don't really need to do anything there, but at least then it puts the infringing party on notice of our rights, lets the USPTO know that we have a pending application. All good things to do.